This is a special report from True Crime Today and the Hidden Killers podcast.
We're going to take you to the Alex Murdaugh hearing that took place today. Jurors being questioned, including Becky Hill, regarding possible improprieties or jury tampering in the Alex Murdaugh murder trial. Let's go there right now.
All right.
Your Honor, for the record, the hearing before Judge Newman to seal the body cam videos was on May 26, 2023. This email is in July, just to give you the context of what's going on.
This is being offered as a after-the-fact email to Rebecca Hill and her replies garnered from the emails that were released by Cotton County at a certain point. And it addresses the issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your Honor.
All right, I'll admit it. Mr. Waters?
As to this specific exhibit, Your Honor?
Yeah.
Your Honor, I mean, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection to
Very
Your
good.
Honor.
All right.
And Your Honor, that's all we would have.
All right, hang on. All right, have you got a copy of it there? I got it. This is his next exhibit. Proffer is his one.
So this is two.
All right, the proffer is your exhibit one, Mr. Harpootlian, and this, which I have admitted, is your exhibit two.
Thank you, Your Honor.
All right. All right. Now we proceed to closing. You prepared?
Yes, ma'am.
Very good, Mr. Waters.
Thank you, Your Honor. Just to go back and reiterate as to the standard, and ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred, and then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or what was inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect on the verdict. And Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen. But ultimately, and while I think there were some cases cited in some of the various South Carolina decisions, that it's unrealistic and not surprising to think that sometimes things like that can happen, an untoward comment or something was said. But that was an Aldrich, Your Honor, in the 1999 Supreme Court case. But the mere fact that something like that may be stated, that could be stated in a neutral reason, is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And, Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that that carries the day. We have the one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence and the law and the testimony at trial. Answered question number 2, yes. Absolutely yes. But then goes on after that to say she heard some communications from the clerk and then says, well, it had an effect on my verdict. Even after she had already answered question number 2 when she said her verdict was based solely on the evidence and the law and the testimony at trial. And beyond that then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors. Not that her verdict was in any way affected from some supposed external influence. In that affidavit that was filed with the defense motion from day one, that is what she says, that she felt pressure from other jurors. And, Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And, Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling. Because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, this juror is represented by Joe McCullough. And ultimately, we've got now a third version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And I think ultimately when you look at the case law, in the end, it's up to Your Honor to make that ultimate determination and looking at all that law together. We cited a number of decisions, including, as we discussed, the questions to be had. I sent an email where we set out some questions that it's not uncommon, perhaps, for a juror to have a second thought. But the law is very clear that it does not recognize that, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation, and the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And, Your Honor, I would say that the other 11 jurors are credible, they were strong, they were clear with Your Honor, and I think that ultimately that carries the day. Now, we've had testimony from other people since the jurors were here. We've had testimony, obviously, from Ms. Hill. We've had testimony from Ms. Rhonda. And we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Miss Rhonda. And Miss Rhonda came in and testified, but I would submit to Your Honor that this is kind of a red herring, because what Miss Rhonda described were conversations that she herself admitted are just the kind of conversations that go on. And that's the reality of it. The conversations that go on among a trial team when we're not in open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors, those types of conversations go on. But that does not mean, nor does that necessarily indicate, that somebody's not going to come out here and do their job fairly. And understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear. And I probably was as repetitive as anyone here today in asking that question over and over again, because I didn't want that point to be lost. That Miss Rhonda said, I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact, because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened. When we look at the balance of those facts, when we have the clerk of court come in and testify that, maybe I did this or maybe I did that, maybe I plagiarized the book, a portion of it, maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was clear that she did not have any attempt to influence that jury. She was clear about that. And Ms. Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the state's star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict, this was the product of honest deliberation, we would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced, nobody tried to influence, and regardless, it was the product of our honest deliberation. and you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
Mr. Harpootlian.
Mr. Griffin will be arguing.
All right.
It's okay if I stand here, Your Honor? That way I won't be interrupted by Mr. Harpootlian as I'm trying to make my points. Your Honor, I want to first start with State v. Green because I understand that that's the guidance, that's what we're following here, and reading, excerpts from State v. Green. First, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different. It was their prejudice. Was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial. The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury in Rimmer conduct which goes to the heart of the merits of the case is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption. That we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we prove prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember, and then we were allowed to show her, and when Your Honor asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this, quote, this shouldn't take us long, close quote, and that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's 2 deliberating jurors down. The third deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. She crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her, and that pretty much came out there. So, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill said, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, you know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask, how? And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It is really an impossible task. Because you don't know what's influencing a jury, and frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty, and there was really no testimony about did that affect your verdict, but it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial, and we're granting a new trial. I mean, this is prejudice, and this has been proven. I mean, Ms. Hill is not credible. Ms. Hill is not credible. And she's talking about her book, talking about taking literary license to lie. Literary license to lie is that's what she thinks a literary license is. So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today. Thank you.
All right. The arguments are closed. I will take until 5 of the hour to examine my notes, and then I will come and make a ruling from the bench on this matter. Court will be at ease.
Order, all rise.
Please be seated. In the matter of the State of South Carolina against Richard Alexander Murdaugh, 2022 GS 15-00592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by Clerk of Court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the Clerk of Court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did Clerk of Court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The Clerk of Court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge, and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.
Thank you, Your Honor.
Thank you. Let me say this, and I should have said it before I began my order. Hey,
Order.
members of the audience, would you just be patient with me for one more minute? Please keep your seats. I have probably had more experience with trial and appellate work than anyone else in this room for many years. And it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the research and the writings that I received. I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is. I've not seen a case such as this before. I doubt whether our appellate judges have seen a case such as this before. And they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
1, which means we met our factual burden. 2, she made it very clear that the law in this area is unsettled at best, and that it means it's ripe for appeal. So the facts are settled. Becky Hill's not credible. The judge found, in fact, that the statements were made to the jurors. She just found that we couldn't show prejudice, but conceded that we may not have to show that if she's wrong about the law and the law's unsettled.
So Becky being not credible if she's wrong helps you at the next appellate level, or maybe the Supreme Court or the federal level?
Next level. Next, we go from here to the Court of Appeals, and then to the Supreme Court, if necessary, our southbound Supreme Court, and then federal court.
I have to be honest with you, I didn't really believe the whole story with Becky Hill until today's testimony, and I have to tell you, it did sway me quite a bit, because I didn't believe it. Explain to us how you found out this information.
Go ahead, Jim.
Well, we're glad you're being honest today. When we found out the information by talking to the jurors. You heard the alternate testify today, and honestly, that was really the first one-on-one interview that we were able to get we had gotten some indications from lawyers who represented some other jurors that we needed to go down this road, and when we finally met with her as she's cooking Sunday dinner in her home down a dirt road, I mean, she told us things that were jaw-dropping, and so that's how we found out.
And we rode down a lot of dirt roads in Colleton County on Sunday afternoons, knocking on people's doors, and that that's shoe leather is the way you work cases. I know everyone's used to social media and electronics, but you got to knock on a door and you got to ask questions, and that's what we did. And that's how we proved to Judge Toal that Becky Hill attempted to influence this jury. She said for the siren call of
publicity and money to sell a book. I mean,
right.
We were denigrated, made fun of, chastised because in our initial filing we pointed out that she had a profit motive for doing what she did. And guess what? Justice Toal ruled that was exactly the case today. So we feel vindicated on the facts. The law is unsettled, and early on she acknowledged, and we all acknowledged, this was not going to be the final say-so on the law. That's going to be determined by the appellate courts, and that's the next step. If we had lost today, I mean, we did lose today. If we'd won today, the state would be appealing. So no matter who wins today, it's just one step in the process. We would not have a trial next week or next month. It would all be wrapped up and gone up to the Court of Appeals and the Supreme Court, and so we're prepared for that.
But the good news is we agree, the court agrees, that Becky Hill attempted to influence these jurors, that she made these statements. With the facts resolved, the only issue is what is the law? And as Judge Toal said, that is unsettled. This is not, it's going to go through the appellate courts, and we feel strongly that we'll win.
Thank you all.
Wait, one more question.
How important is it to you all to get a different standard for the burden of proof when you appeal this? Do you think you can win under the burden of proof that she set, or do you think you need the burden of proof that you all want?
Well, we feel confident that the burden of proof is, that we get a presumption based on her factual findings here, and so if we win that legal standard, on this record, we get a new trial. If we lose that legal standard in our state courts, then we probably don't get a new trial. But we go to federal court where there is no dispute in the Fourth Circuit where we would end up with what the standard is, and it is a standard of presumption. So it's either going to be decided, in my view, in our favor in our appellate courts, or 4 or 5 years down the road in the federal courts, unless there's a change of federal law.
And would there be a different outcome if you get another trial?
Yes, there would be. But I'm not going to tell you why.
Absolutely, yes.
But it doesn't discourage you that Justice Toal at the end said she agreed with Judge Newman about the facts and the verdict and how it was, that it was a compelling case and all of that.
No. No. She's not going to say, oh, I disagree with Judge Newman. The facts were very thin. No, she's not.
Yeah, there's an innocent man here who's wrongly convicted. And we didn't expect her to say that. So.
But the appeals court could say it's harmless error, is my point.
No,
they can't.
No.
They can't. This issue is not harmless error. Cannot be.
I've asked about this before. You all have said that you're investigating who might have actually committed these murders.
Yes.
Have you all found anything that you think you want to share with us?
We have developed some information. We want to get this behind us, and we'll be pursuing that in the near future.
About who committed the murder?
Who really did it?
Do you believe Alex Murdaugh has information? Because his voice is on the kennel video. Do you think he has information about who did it?
Well, if he did, we couldn't tell you. That's called attorney-client privilege.
I know, but do you think is the question?
I can't think about what my client could have told me that would be attorney-client privilege. These rules, they're so pesky.
You have to give me credit for trying, though.
You get credit.
Yeah.
How did Alec react to that?
Thank you.
Pardon me?
How did Alec react to that?
Fine.
Hey, get up.
Be careful.
Thank you, gentlemen. Take care now, Turner. I think those Turner was just swimming up here. You know what I mean? Swimming down, and when they got ready to drown, you grab at everything you can. That's what I think. They just swimming up here.
Nicely done, man. You got the best and never far back.
I know, right?
Are we done or we got to stay here? What do you think, King?
Thank you, sir.
When
Yeah,
you're
buddy.
drowning, you're going to try to grab everything you can. Don't care what it is. We hit that stage, you try to hold on to it. And I think that's what they did there. When you're drowning, hold on.
Good afternoon, everybody. On behalf of my 5 jurors that I represent, we're very pleased with the decision that Justice Toal rendered. This is what justice looks like. Sometimes it's messy, sometimes it's easy. This was not as easy as it looked. There was some very good lawyering on both sides, the defense and the prosecution, but the law is clear. And you heard from 11 jurors in no uncertain terms that their verdict was their own conscience. It was not influenced by anything that may have been said or done by anybody other than the testimony, the law, and the evidence. They followed what Judge Newman told them to follow. Yes, there was one juror. I don't question her veracity in whatsoever. I disagree with Mr. Harpootlian. Nobody on our team ever called that juror a liar. That is her conscience, and like the state said, we can't have verdicts that go in perpetuity and jurors can constantly say, well, this was my verdict then, but today it's different. You vote once in time. And I think Justice Toal believed that the verdict was the product of free negotiations. Yes, inside a jury room, it's tense. You often hear that there's arguments one way or the other. But she did not feel that this verdict was the result of anything that Becky Hill had said or did or any other court officer. And so, this is the verdict that we have. Our state supports this verdict. You saw how hard the state fought to keep this verdict, and we cannot continue to have trials go over and over again when you have jurors that hear evidence over 6.5 weeks, over 70 witnesses, over 400 pieces of evidence, get the instructions from the judge, give their time, are smart, bright people who come with their God-given common sense, render a verdict, and then are polled and raise their hand and say, this was my verdict. And so...
Well, here we have an issue of, as a legal professional that I once was, I have a problem with some of the things that we heard Becky say. I'm thankful that it didn't sway the jury. But we have to be...
Oh, I have a big problem with the things that Becky has said. And it's clear that there was some inconsistencies regarding whether she rode with a juror, what was said, what was heard. And I think Justice Toal let the public know and let Becky know exactly what she thought of some of her testimony, and I don't think we've heard the end from Becky, and that she may have to answer for some of the things. I think Justice Toal gave a foreshadowing of what may be coming to Becky.
Yeah. Did you pick up on how much Justice Toal impeached the testimony of Becky Hill?
I wouldn't say impeached. I just think that she didn't believe a lot of it. But it's not her job. Becky Hill was not on trial. This is not Becky Hill's trial.
Her credibility was a key question, though, in this case, and she was impeached regarding...
No, her credibility was not the key question in this trial. The key question in this trial was what was the jurors' verdicts. That's it.
Correct, but her credibility regarding what she said or didn't say in front of them is a part of that.
It's not, because the ultimate question was...
whether they were in the line.
Right, and she already discarded, I believe, what Becky said. I don't think she believed that Becky didn't say anything. I think she believed that Becky actually did say a lot. And I think that
That's
Becky...
my point.
Right, but that had nothing to do with her decision. The decision was, what did the jurors say? And that's what we were dealing with between the time the trial started and the time that they rendered their verdict. Not what may have happened since March 3rd. Since March 3rd, obviously, there's plagiarism allegations. There's allegations that, obviously her son was indicted. There's allegations of ethics complaints, and there's allegations that she's being investigated. And all that will take place in due course. And what we're going to ultimately see, what Dick Harpootlian said is our state Supreme Court going to say, we stick with the Green decision, or do we go back to the United States Supreme Court decision in Reamer, and all a defendant has to show is that a court official makes these kind of substantive merit statements to a jury, and if they do, does it guarantee them a new trial? I don't think at this point we know that it's the Green decision, and you have to show that impact on the jury. Thank you.
That's the latest. Be sure to press subscribe so you don't miss any of our coverage in the Alex Murdaugh murder trial and the hearings about possible jury tampering. I'm Tony Bruschi. Stay with us.
This has been a special report from True Crime Today and the Hidden Killers podcast.